Indecent exposure. Have you been charged with indecent exposure in Texas? Can it be beaten? How should you prepare your defense? Hi, I'm Jeff Hampton with the Hampton Law Firm, and I want to welcome you here today to our YouTube channel because I want to talk to you about the crime of indecent exposure. There's a lot of bad information out there about this crime, and people become confused about what it is and what it isn't. And quite frankly, there are a lot of police officers who are confused about this issue. So I want to clear that up for you today. And by the way, if you wait around to the end of this video, I'll provide you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, let's jump right into this. Listen, indecent exposure is a pretty serious criminal offense. Because listen, you do not want to be convicted of this, particularly if you're a first-time offender. You do not need a crime with the language indecent exposure on it on your record because it makes you look like you've got some sexual deviancy. Maybe there's some type of issues going on there, and people will have a tendency to judge you immediately based upon that conviction. It can also result in a difficult time finding an employment or meaningful employment, and it can, depending upon the charge, it can also potentially require you to register as a sex offender. So what is indecent exposure? Let's break down the law. Number one, under Texas Penal Code section 21.08, the state of Texas is required to prove the following elements of indecent exposure beyond a reasonable doubt. So a person commits the criminal offense of indecent exposure if he exposes his anus or any part of his genitals with, and here's what's critical, with intent to arouse or gratify the sexual desire of any person, and he is reckless about whether another is present who will be offended or alarmed by his act. Now, the Texas Penal Code states that we need to define recklessness, right? Because you heard the term reckless. The Texas Penal Code defines recklessly as an individual is aware that their conduct can cause the result of their actions, but consciously disregards the risk that the result will occur. Now, let's talk about, just very quickly, the definition of it sounds simple enough, but let's talk about some of the legal defenses to indecent exposure and what you need to be aware of. Defense number one is inability to prove, quote, intent to arouse or gratify. That's our first defense. And I'm going to tell you, when you talk about this defense, it's probably the most litigated and contested issue in most trials for indecent exposure. Exposure is, think about it this way. When you look at what indecent exposure is, it's whether the individual intended to arouse or gratify the sexual desire of another, and whether or not the individual acted recklessly regarding whether someone would be present. Now, let me give you for an instance. One of the most common instances of an arrest for indecent exposure in Tarrant County, and we see this happen quite frequently actually, is when someone urinates in public. Now, I know this is kind of difficult to talk about. We've represented a number of people in this situation. Now, listen, although technically urinating in public can sometimes meet the definition of an indecent exposure, it is often difficult for the prosecution to prove this situation beyond a reasonable doubt to a Tarrant County jury. Why? Because we're able to show that the exposure was not done to arouse or gratify the sexual desire of any person. Even though the accused may have technically been reckless in exposing himself or herself to urinate, without proving that additional element, the state of Texas must prove that extra element of having the intent to arouse or sexually gratify the desire of another. The state of Texas will lose their case if they cannot prove that element. Let me give you an example. We had a client that was invited to play golf at one of the local golf courses here in the Fort Worth area. He made it out to the 7th hole and he realized he just couldn't hold it any longer and he was going to have to use the restroom. He couldn't wait till the 9th hole, and so he went over to one of the wooded areas where he was out on the golf course, and of course he exposed himself to urinate. Now, what he did not realize was there was a lady up on the 5th floor of the apartment complex out near that golf course who looked down and saw him urinating. Well, this woman was quick to be offended by anything, and immediately she became very upset, called the police, alleged that this man was exposing himself, and it could have only been for one reason. He was only exposing himself in order to sexually gratify her. I mean, that had to be what it was for, is he was attempting to arouse her. That's what it was all about. Now, did this man commit the crime of indecent exposure? No way. Listen, the state of Texas would not be able to prove that he exposed himself with the intent to sexually arouse or gratify another. I look, this is hard to talk about, but I think we know when a man is sexually aroused, okay? And that evidence was not indicated in this particular case. There was no evidence that this man in any way was aroused based upon when he exposed himself. He may have committed the lesser offense, Class C misdemeanor of disorderly conduct by exposure. And under Texas Penal Code section 42.01, that crime requires the state of Texas to prove that the individual intentionally or knowingly exposed themselves in a public place and they were reckless about whether someone else would have been offended or alarmed. Okay, maybe he did that, right? And even if you were to take that offense of indecent exposure and drop it down to this Class C ticket of disorderly conduct by exposure, it's quite a bit different, because under that arrangement, it's much easier to resolve the case in a manner to get it dismissed and ultimately expunged from your criminal record. So another problem scenario where the state of Texas may not be able to prove intent to arouse or gratify the sexual desire of another is when there is no evidence of any arousal at all. What if an individual did clearly expose themselves, but there's no evidence of arousal at all? Now, the most common way we know how that is, I kind of alluded to that already. If it's a man, you know that you're looking for an erection. And if you don't see that, you literally have reasonable doubt. It's going to be very difficult for the state of Texas to be able to prove that, okay? So here's the point. Number one, that the lack of that evidence shows he was not doing it to arouse himself. Then we have to turn it independently to see if his actions would have been sufficient to show that he was attempting to arouse the victim. Now, I know this is hard to talk about this, but this is the analysis that needs to be done if you or a loved one is facing indecent exposure charges, okay? Now, merely seeing someone exposing themselves does not by itself establish proof of intent to sexually arouse or gratify the person who saw them. This is the type of analysis that we're looking at. Did the person, when they exposed themselves, do something in conjunction with that that would make it clear they were attempting to arouse that person? Those are the kind of questions that need to be answered. Defense number two, the inability to prove recklessness. The state of Texas must prove that you had the intent to sexually to arouse or gratify the sexual desire of any person, and the act itself must be reckless about whether another is present who would be offended or alarmed by the act. So proving only one of these elements is not going to be enough. So even if someone exposed themselves with the intent to arouse, okay, think about this. What if that is pretty clear? He did it with the intent to arouse himself or another individual, but yet those actions were not reckless, but instead negligent, not reckless, okay? Now, is it really an indecent exposure? Now, I've already covered what it takes to prove the element of recklessness. Go back up to the beginning of this video and you'll hear that again. But I'm going to give you an example. There have been instances where someone have exposed themselves in their residence when there was an open window and a neighbor saw them. The determination of whether the actions were reckless becomes a very fact-specific inquiry. Was the choice to expose themselves reckless in regard to whether someone else would be present to see and be offended? Now, you understand this is kind of a pretty detailed inquiry here. Here, I'm going to give you an example. If the window were pointed right out to the neighbor's house, like let's say someone's changing and they're exposing themselves or they're doing something else for sexual gratification, and it's clear that the neighbor's going to be able to see that, it would probably meet the definition. But what if it were pointed out into the forest where it's very unlikely anyone would have been able to see them at all? That would be harder to do because they weren't necessarily acting reckless in that situation. So I want you to understand, now here's the only other question I get. I've had people ask me, what about breastfeeding? What if a woman exposes herself when she's breastfeeding? No, that doesn't count. There's an exclusion under the law that basically says that does not count as indecent exposure. All right. Now, what are the criminal consequences? If you are convicted of an indecent exposure, it's a Class B misdemeanor up to 180 days in jail and up to a $2,000 fine. If you already have a previous conviction or probation and you pick up a second indecent exposure, you are now talking about a higher level offense of a Class A misdemeanor where you would potentially have to register as a sex offender in the county you reside for a period of 10 years. And so that's very serious. Okay, it's very serious to make sure these are handled properly. So the way to go about this is you need to hire an experienced criminal defense attorney who is going to go over thoroughly the evidence in your case, look to see if, number one, it can be dismissed for a lack of evidence. So I want you to understand, if the state of Texas cannot prove each and every one of these elements beyond a reasonable doubt, your criminal defense attorney should push the case and do all that they can in order to make sure that the case is dismissed based upon just the lack of the merits of the case itself. The facts don't support the charge. But in other instances, particularly if there's a weak case, your defense attorney may be able to get what's called a conditional dismissal. A conditional dismissal is in exchange for you doing some items on the front end, maybe some community service, maybe a class. Then the prosecutor may then be in agreement to dismiss your case. And remember, the goal on all this is no jail, no conviction, and get it off your record. That's always the goal. And every one of these speak about that. Number three, so we've talked about dismissal on the merits. Number two, a conditional dismissal. Number three, what if it's dropped down to that lesser charge we talked about earlier? If it's dropped down to a Class C misdemeanor, lesser offense, it could be resolved under a deferred disposition that would then make you eligible to still be able to get that completely expunged from your record. And then finally, under both the United States and Texas constitutions, you have the right to a jury trial. If your prosecutor's unreasonable, you can absolutely make sure and force them towards a jury trial to be able to show the jury you did nothing wrong. Okay. Now listen, if you or a friend or a loved one have been arrested for the crime of indecent exposure in the North Texas area, I want to invite you to give our office a call here at the Hampton Law Firm at 817-877-5200. I'd be happy to give you a free case analysis and a consultation. And I promised you, if you waited around to the end of this video, I'd give you a free ebook. All you have to do is click the link below down in the text that you'll see down here, and I'll be happy to send you over what to do if you have been charged with a crime in Texas. Thanks for joining us here today. I appreciate you watching our video. Subscribe to our YouTube channel. Like the video if you liked what you heard today. Thanks again.